Tim Madden is an economist from British Columbia who was forced by personal legal circumstance to study and uncover a web of fraudulent practices that permeate the world of banking and credit. He works now on behalf of private individuals and corporate clients as an analyst in tax and banking disputes, and has written a major critique of the practice of banking in Canada over the past 100 years. This particularly important material applies just as well to conditions in the United States, so it will be worthwhile for American listeners to give this your full attention. I'm sitting with Tim Madden, who is a financial scholar from Canada, and we're going to be talking today about some of the basic things which we all have to deal with at this point in history. So the first thing is I'd like to just get some clarity from you, Tim, on the credit card phenomenon, the fact that our culture is addicted to credit cards and dependent on credit cards, and there's a great deal we don't know about what these pieces of plastic really do to us and how we are, in fact, managed by them. The first question I have for you is, let's say you think you can use a credit card responsibly and beat the system by paying it off within the first 30-day period. You have a free loan. Is that, in fact, the case?
No, in fact, that's not true. Their point of view is to get what is called a merchant discount. When you use a Visa card, for example, you go into a merchant establishment and you charge $100. You think you're paying $100 and the merchant accepts your card. The merchant, on average, is only going to get about $97 from Visa or from the bank that he takes it to. Now, it's a little bit complicated because there's two banks generally involved. The merchant has a bank and the cardholder has a different bank. Not always the case, but sometimes. So what happens is you are actually paying for the merchandise with your paper, with the Visa voucher that you sign. That is not merely what is called an evidentiary instrument of a loan that they have loaned to you. It is, in fact, a funding instrument. They put on their books that they have received a $100 piece of paper from you. It's a bill of exchange under the Bill of Exchange Act in Canada. It serves the same function under the Uniform Commercial Code in the United States. What happens is the merchant takes this $100 bill that you have issued and paid. It's just like a check. When you write a check to a merchant for $100, the merchant will generally get $100 from the bank because he has ordered his agent, the bank, to pay you $100, and the agent has to do it. Now, with a credit card, it's exactly the same thing. For example, you write this $100 check for an item, and let's say the merchant doesn't take the check to the bank for, say, 4 days, 5 days, whatever it is. Then the property interest in the merchandise passes to you as the instant the merchant accepts your check. It is now your merchandise, and if the check bounces, you're in serious trouble. And that's part of the reason, is because the property interest in the merchandise does pass to you upon what is called acceptance of the check by the merchant. Now, the merchant then takes the check to the bank and deposits it into his own account. At that point, his bank purchases the check from him as a holder in due course. That bank then goes to the Canadian Payments Association, and the check gets passed on to the check writer's bank, who then purchases it from the Canadian Payments Association and presents it against your account. Meantime, if it takes 4 or 5 days to get there, you can be collecting interest on the money in your account that the check was written on. So you can see that the increase in the purchasing power when you write that check is quite real. You both buy the merchandise on the spot at that time, and you're earning interest on the same money that you are attaching to that check for that 4-day period that it takes to get there. Well, that increase in purchasing power is your property because it's your check and you issued it. Now, the credit card mechanism is a complicated way of shuffling things around with the issuing of the Visa voucher or the MasterCard voucher or the American Express voucher or whatever it is. There's still a $100 increase in the purchasing power. Only the way they work it out is the bank gets the benefit of that increase in purchasing power at your expense, and you don't even realize it's happening. What happens is the merchant takes your $100 voucher, and he has to sell it to his own bank for $97. That bank then takes the same bill of exchange, the $100, and writes in its own account that it has required an asset of $100. And it says, we got from the merchant $100, and we issued back to him a credit for $97. They're not loaning any depositors' money, and they're not loaning any of their own money. In fact, they are funding that transaction with your bill of exchange. So the merchant's bank writes down on their books that they received an asset for $100, and they issued a liability to the merchant for $97. then they pass on and sell that instrument to Visa International or MasterCard International, etc. for $98.25. And the merchant's bank makes $1.25 on that transaction right now. Like there's no waiting period, nothing. And that cancels out the $100 asset, but it is traded for a $98.25 credit from Visa International, which balances out the liability to the merchant for $97, and it leaves a $1.25 residual. Now, Visa International takes that bill of exchange, that $100 bill, and sells it to the card user's bank. The card user's bank will pay $98.75 for it. So Visa International earns 50 cents on that transaction right now, just by passing it along. Then the card user's bank will mark on its books that it has issued a $98.75 liability to Visa International and that it has acquired a $100 asset, being your bill of exchange. Then they will present it to your account, and suddenly this bill of exchange that was used to fund the transaction back at the merchants becomes, poof, a promissory note for a loan that your bank made to you back at the merchant's establishment. Say, that isn't true, but you believe it's true, so they put on their books that they have acquired a $100 asset and issued a $98.75 liability to Visa International, so your bank makes $1.25 on that transaction as soon as you pay them at the end of that 30-day period. If you take the three of them, I call them the Visa Triad or the MasterCard Triad, the three entities that are involved in any given transaction, they issue $97 of credit to the merchant that is funded by the bill, and at the end of 21 days they receive back $100, and they make, among them, $3 profit on a $97 credit. So even if they were loaning their own money, they would make $3 on 97 for 21 days, which is an effective annual rate of about 68%.
The person that's losing in this transaction, if you pay it off by the end of the month, is actually the merchant. It's mostly coming out of the merchant's pocket, because if you gave the merchant a check, the merchant would get a full $100.
Correct.
As far as you're personally concerned, your money is being used by two other crafty entities, the other two banks, to make money from. They're, in a sense, borrowing it from you, but not paying you any interest. They're keeping the interest. It sounds very complicated, but in fact, the net effect is if you buy something for $100 and you pay $100, you don't pay any interest on it yourself. It's just that the bank is taking advantage of the fact that you don't have to pay for a month. They're borrowing your money for a month from you. Because when you wrote that bill of exchange, when you signed your signature, you temporarily created a new $100 for them to play with.
Exactly.
Because it's so easy to move money around like this, of course, what happens is that people don't pay it off by the end of the month.
Correct.
And then they don't pay it all off by the end of the month that follows that either, and they keep using it, and the bank or the credit card company is always asking you to please pay the minimum, and that minimum is quite low. So it's a quite attractive way of delaying facing the fact that you've spent this money. As we all know, the whole society is now deep in credit card debt because it seems like a good idea at the time, but it's very easy to forget to pay it off each time. So we have people in a desperate situation because they have thousands of dollars of credit card debt, and then eventually they cannot pay it. So that's what I want to turn our attention to next. So what is the information that people in this situation need to know, which the credit card companies will not tell them, as to how to resolve this emergency?
The big crime that is being committed in this whole situation as it is set up and implemented is called receiving secret commissions while acting as an agent. See, the credit card company is your agent. You're telling them, look, I've bought something for $100 from this merchant. I want you to pay the merchant $100. Now, this is exactly the same as if you had paid $10 to Purolator or UPS or Federal Express. Said, look, I want you to deliver a package to my parents in such and such Colorado, say. And Federal Express, without your knowledge or consent, goes to your parents and says, we have this package for you, but we're not going to hand it over unless you give us 3% of the value in the package. That's a crime, and it's called receiving secret commissions while acting as an agent. That is what the credit card companies are doing every time they effect a transaction. In fact, there's about 30 different criminal offenses every time you throw that lever and go ching-ching with your credit card and charge something. So what it does is it taints the paper. The bill of exchange becomes a constructive forgery in law. There's another section called omitting material particulars from a valuable security. The Visa voucher is defined as a valuable security in law. They have a duty to tell you on the face of it. They know what it is when you buy something, that there's a 3% discount or 2% or 1.5%, whatever it turns out to be. With American Express, it's as much as 6%, which is why merchants hate it so much. It does taint the paper such that it becomes uncollectible. Your bank, the Visa issuing bank, what it does is it debits your account that you have signed for up to a maximum of $5,000, $10,000, $50,000, whatever it is, for the proceeds in order to pay the bill and take their discount at that time. Now, when they convert it like that, that's technically money laundering. And it means that the contract itself is completely unenforceable. But it has to be done not through the courts, but through a process determined under the Bills of Exchange Act. If you read your credit card agreement very carefully, you will notice that often they will use the expression waive presentment. What you're agreeing is that under the Bills of Exchange Act, if for any reason there isn't money in your account to honor this bill that they present against it, and they refuse to increase your limit or whatever it is, then theoretically they have to come to you and give you 72 hours or 3 business days to make good on it. But by waiving presentment at the time you enter into the agreement, they don't have to do that anymore, and they just debit the account directly. But it shows that they know what they're doing. Now, if this is not disclosed on the face of the document, then the paper becomes unenforceable. It's difficult to explain because the contract itself, your credit card agreement, is in and of itself a bill of exchange.
Can you describe unenforceable or define unenforceable in this situation? Where would this come up that it would be unenforceable?
It effectively is a conspiracy by the Visa Triad to prevent you from realizing that you are participating in a secret commission scheme, even though you have agreed to it. You'll notice if you read the card user agreement, what they do is they deliberately avoid telling you what it is they're going to do for you under the agreement. You're just left to assume it, that what they're doing is delivering 100% of the proceeds to the merchant. It just taints the paper, and you can't enforce it.
Meaning can't enforce it because you can't collect on it, or if it's challenged, it won't hold up? Is that what you mean?
Yes, exactly.
Okay, well then, let's say that you have $10,000 in credit card debt, and it's becoming a nightmare, and you find out this information. What are the consequences to you of beginning to realize what's been happening?
Well, the first thing you have to realize is that you can't lay back and don't let them take the offensive. You have to take the offensive. You cannot win this battle from a defensive posture. You have to go after them. You have to demand they explain themselves.
So let's say you've been paying your minimum payment all along, so you're not in default. When you say take the offensive, you mean at this point you should start taking action rather than wait until you're in trouble and wait until they're trying to collect from you and you've missed some payments.
Absolutely. The courts will seize upon the fact that you are in default, and they won't listen to a word that you say. They will just say, oh, you're just trying to avoid paying this debt, et cetera, et cetera. If, however, you take the offensive when you are not in default, then you have the upper hand, and overwhelmingly so.
Give me a scenario of how I would initiate that and what my motive would be in doing this.
The motive is you want to avoid participating in what is legally defined as a criminal organization. You are dealing with a situation where, under Section 21 of the Criminal Code, if you with knowledge participate in this scheme, you become a party to it, even though you are the victim in a sense.
Or a totally unwitting participant. I didn't know that I was participating in a crime until after the fact.
Yes, until somebody told you.
Right.
And
so you're telling me now, and I'm suddenly realizing that.
Exactly.
Okay.
Now is the point where you have to do something about it. You have knowledge of it. Of course, you're always paying 3% more for everything you buy, unwittingly, because the secret commission is buried in the price of the merchandise. And if the merchant tells you about it, he's in trouble. In any event, what you have to do is you have to inform them. You have to write to them, and you have to give them an opportunity to cure the defect, to say, look, I'm not trying to be unreasonable here. I'm not making any accusations. It just appears to me from this information I have received, you never told me you were using my money to finance this transaction. You led me to believe very, very carefully that I was receiving a free loan and that I was having the use of your resources when in fact you were using my resources and you were skimming 3% off the top of it every time I rolled it over. So these actions of yours, the apparent actions, Mr. Credit Card Company, appear to offend all of these different sections, and you have to do a little bit of research and find out which of them are being offended. And as I say, there's about 30 of them. It's not difficult once it's pointed out. You go, oh yeah, that's really bad. They shouldn't be doing that. And then they have to cure. They have to come back with a reasonable explanation as to what is happening. And we've been sending these things in now for almost a year, and nobody is responding.
In other words, you outline this question, as it were, or statement of discovery, that you've come across this information and you put it all in a letter which is properly worded.
Yes.
You send it to the credit card company and you say, because of this, I no longer want to participate in a criminal action. Therefore, it seems improper for me to make any payments on this thing which was fraudulent at the start, even though I've used this up to the extent of $10,000 and I've been paying on it every month. I see that that is an error, so I'm going to stop now.
Exactly.
That's it. And then you don't pay any more unless you get a reaction. And what you're saying is that when you send this letter for the last year, in Canada, you've had no response.
We've had responses when people simply send the letter in and don't do anything else about it. If, however, you send the letter and have it notarized, which is a form of registration, such that they cannot deny, and you send it by registered mail or by courier or what have you, they're afraid to respond. They can't respond because you've got them sort of trapped between a rock and a hard place. They're committing two fundamental crimes, but the two crimes that they cannot seem to weasel out of is the fact that they're using your money without your permission to fund the transaction, and that's a fraud in and of itself. And on the other hand, they're receiving a secret commission while acting as an agent, even if it were their money, which it isn't. So you've got one crime compounding the other, so to speak. Now, when you register that and you formally put them to the test, and we call it a notification of suspension of the account pending a resolution of the following issues, and force them to respond, they don't have any choice. What are they going to say? Too bad. You signed the contract. But you see, part of the research is the English law principle that applies throughout that says if the issue of fraud or misrepresentation or these issues are raised, then the contract itself becomes unreliable because it's kind of silly to rely on a contract where you're alleging fraud. So what's been happening is the people who have registered these documents and given them the opportunity to formally cure the defect under the Bills of Exchange Act, we're not hearing anything back. I was just talking to a woman. She sent the letter in. It's a 20-page report, but it's fairly straightforward, and it's very reasonable. She says, look, I'm trying to be reasonable here. Convince me that you haven't involved me in this criminal enterprise, and I'll resume payments under the contract. She notarized it. She gave them 3 days to cure the default, 72 hours, which is the standard under the Bills of Exchange Act. She gave them a second fault, another 72 hours, and then she gave them a 10-day final notice to cure the default, and that was last August. She hasn't heard back from them yet.
Now, is it still possible that she might hear back from them at some time, or has the fact that they've outrun their 72-hour response time or whatever she indicated, is that
it's final?
Closed it?
That's the end of it.
It's presumed that it is dropped.
Yeah, and they'll do that to you, too. You'll notice that if you're being sued by somebody, they will send you documents that give you 72 hours to respond or 10 days or whatever point in the process you're at. And if you don't respond, they will get a default judgment against you.
Right. So the details of the language are, of course, very important. It's not something that you'd recommend somebody just improvise and try out. It needs to be done with a good knowledge of all the statutes.
Oh, absolutely.
So it shouldn't be done by a lay person, as it were, unless they've specialized and studied this. It's something that you can assist somebody with if they need the help with that.
You have to do your homework and know what you're talking about, because these people will try and bamboozle you and try and, the shell game, shuffling, whatever it takes, to get you to take your eye off the ball for a minute, and then they'll try something new. But if you stick by your guns and you say, no, we are not going anywhere until you cure this default, once you put them through the formal steps, the 3-day, 3-day, and 10-day period, they're dead in the water. There's nothing they can do.
Now, what happens, if anything, to your credit status?
You've got sections 300, 301, and 302 of the Criminal Code, which make it a criminal offense to threaten libel. If they threaten to report you to a credit reporting agency without full details of why you stopped paying, then they are guilty of committing extortion by threat of libel, is what it's called. They're basically saying, look, either you do what we tell you to do, or we're going to badmouth you to the credit reporting agency and you're finished. That's a criminal offense of itself. And even if they have cause, they can't do that. And so you have to make them know that you are aware of this.
Generally, people get things on their credit report all the time which are inaccurate, so it's easy to allege something and have it show up there, and it's still a nuisance to get it cleared up. So to prevent it, you have to let them know in advance that you won't allow it, and then if it happens anyway, what steps do you take?
What you would do is that you would then launch an action against them and sue them for damages. You would have to make some kind of an estimate of what it is costing you to be cut off the credit system, essentially quantify the damages from the fact that they have libeled you. That's a civil action and not a criminal action. But you can seek, double, triple damages and that sort of thing.
But so far, have you seen this problem with the credit agencies come up as a result of the letter and cutting off the payments to the credit card companies?
No, I haven't seen it except in cases where they've been in default already, such that the report has already been made when the process stops, and for whatever reason they don't seem to go and remove it. We sort of nipped it in the bud by having a few people that we've come in contact with who have done this from an upper hand position where they haven't been in default, and the banks just go away, basically.
Now, a lot of us have credit debit cards, sometimes combined, and you have a choice with certain merchants as to which form of application to use with this card, whether you want it as a debit or a credit. Can you talk about the differences and some of the implications of that?
Okay, you notice if you go into a supermarket, Safeway or something like that, the clerk will always ask you these days whether you want some extra cash with that if you're going to use your debit card. And so you can take an extra $20 or to $100 or whatever it is. So clearly the banks don't have any general objections to supermarket clerks acting as bank tellers. And in fact, it reduces their need to handle cash, so it reduces their costs. They're all for it. If, however, you're paying for the same bag of groceries with a Visa or MasterCard, which is becoming increasingly common, there's no way they will let you have extra cash because there is that 3% discount that is attached to it, that the credit card companies are absolutely paranoid that you, the cardholder, do not know is there. Because if you did, you'd realize that that free credit is in fact costing you about 40% per annum. It's a huge amount of money. In Canada, they're skimming approximately $3 billion a year off the top of the economy in these so-called merchant discounts. And any merchant who dares to reveal it is cut off fairly quickly. We had a fellow in Nanaimo who had an independent gas station, and he put up a sign that said surcharge 2% to cover the cost of the Visa discount. And within 2 hours, the banks were calling him, and they had found out about it and said, you take that sign down or you're finished. Read your contract. It says you agree, and this is illegal too for them to put it in the contract, not to discourage people from using the Visa card as preferable to any other payment instrument. They won't say cash per se because they know that the stipulation itself is illegal, and so they use the most amazing language, legalese to achieve this. For example, in Boston, in 1991, there was called the Boston Fee Party when all of the restaurants revolted against American Express because they were demanding 5% off the top of every bill. And the customers, of course, were insisting on using it because they think they're getting a free loan. It doesn't cost them anymore. And it happened in Toronto, too. They made an example out of one restaurant that put little display cards on the tables that said, we pay 2% for Visa, 3% for MasterCard, and 5% for American Express. Please use cash or check if you can. These things are incredibly expensive. And there's a big picture on the front page of the Boston Herald, I think it is. It said, the Boston Fee Party, and had a picture of this restaurateur with this American Express card impaled on the end of this foot-long butcher knife. And, the official story was that only the chairman of the board, who was James Robertson III at the time, of American Express, could set the rates. The salespeople who went out there to sign up the restaurants, they had no discretionary power whatsoever. The 5% discount is carved in stone. But it's different for gasoline than it is for meals in expensive restaurants, because the margins on gasoline are so tight that you can only handle maybe a 1% discount, 1.5, whereas the price sensitivity in an expensive restaurant is far less a factor, and so they can conceal a 5% secret commission in the apparent price of the meal, and it becomes quite a bit more, even though according to their official story, the price at the fancy restaurant, the discount, ought to be substantially lower than the gas station because the average charge is $200 versus $30. So if you look at Amex advancing $95 and getting back $100 21 days later, that's an effective annual rate of 144%. And
They're doing well.
No, they're doing
very well. Now, just to clarify, so when you use the debit card and the clerk says, would you like some cash back, we just don't recognize that question never comes up when we use the credit card, of course. They don't say, would you like some cash back when you offer to use the same card as a credit card rather than a debit card.
Well, yes, the Safeway clerks are trained not to ask when it's a Visa or MasterCard and only to ask when it's a debit card. I was speaking to a restaurant in Vancouver. They had a big sign up recently, and it said, we don't accept debit cards because there was a 31-cent transaction charge. So on a cup of coffee, that's an expensive transaction. So they couldn't take the debit card. Your average Visa MasterCard charge is about $100 overall. So your 3% is costing you $3. So they're claiming that the transaction cost on a debit card is 31 cents, but the average transaction cost on a Visa is $3. See, it's a tenfold, 1,000% more increase. As an economist, I know that a good, healthy economy is supposed to grow at the rate of about 3% per year. These guys are encouraging everybody to run the purchase through the transaction, even if you don't need the credit facility, or what you believe to be a credit facility, for the purpose of getting this free loan for 21 days, whereas in fact, they are taking 3% off the top every statement period. There's about 10 of them in a year from their point of view. This is about every 36 days is what's called a rollover period. So that every 36 days, these people are raking 3% off the top of the economy at an annual rate of about 45%. So you see, all of this hyperinflation in the economy from all this money that's being created by these institutions is being countered and balanced by a hyper-vacuum effect of sucking the liquidity out of the economy through these fees and transaction fees. And you get them on checks as well, but mostly on Visa, MasterCard, American Express. And the debit cards, it's still substantial. It's very much, because they're also demanding the same from the merchant. Because when you use a debit card, you're paying 31 cents, so is the merchant, so they're collecting 62 cents. That, too, is secret commission while acting as an agent.
Is there any remedy that you can use vis-a-vis debit cards? I don't quite see how that would be in any way the same.
No, debit cards would be very, very difficult to get your remedy because the money is instantaneous. It's gone.
That's right, and it's coming out of your account.
Right. So you'd have to force them to pay back the money to you. It could only be handled by some kind of class proceeding or class action lawsuit. You couldn't do it on an individual basis. It would be very difficult.
Hypothetically, as an exercise in imagination, let's say that we have, I don't know how many billions of dollars or millions of dollars in current credit card debt as a nation. And let's say that 50% or 20% or 100% of the people suddenly woke up to this information which we've just gone over and all wrote that letter. What would that look like in terms of the economy and the way banks and credit card companies work?
Basically nothing. I won't get into the complex details under the Bank Act, but the Bank Act recognizes that the credit card operations are essentially free money to the bank. It costs them nothing to be able to support this because, okay, in Canada you've got like $100 billion going through the system, the Visa system alone, actually $110 billion every year throughput. So given 10 rollover periods in a year, at any given snapshot in time, there's approximately $10 or $11 billion of these bills of exchange in circulation. All the bank is doing is sloshing the same money between the accounts of the merchants and the card users every 36 days. And they're taking a 3% rake off every time they do it. Now, if everybody were to say, no, I'm not going to pay because of this, then it would cost the banks their aggregate ill-gotten gains from that operation. But the Bank Act recognizes that it's free money to them, and so that they have to write off your credit card account after 180 days, 100% if it's in non-performing, if it's in default, whereas with other loans they can sell it to somebody else. Essentially, you've got this huge bubble of debt, but there's nothing behind it. It's just a fiction. It would disappear, people would be out of debt, the banks would say, oh, gee, that's too bad. But it wouldn't
collapse the economy.
No, it would be the most...
it would actually be a great benefit to the people to do this, and everything would continue pretty much the same. It's just no one would be using credit cards anymore.
Or it would just get rid of the merchant discount system.
That's right. It would become a true credit card the way we always imagined it was working, without the hidden cost going out of the pocket of the merchant.
See, all the credit card company is really doing is providing an insurance service. And this was what blew me away when I was testifying in 1991 before the Commons Committee. They were giving this idiot story, this really unbelievable story about 50% of the cardholders being free riders and the other half being interest payers. And that the reason that credit card interest rates were so high was that the half that pay interest have to carry the load for the other half who are free riders by paying off their balance every month. They don't explain that the banks are, in fact, even if they weren't using your paper to finance it, they'd be collecting 40% as an average rate on that rollover. But if you look at the figures, in 1991, for example, they had $10.8 billion of outstanding credit card debt. They ran $40 billion through their mechanism over that 12-month fiscal period, and at the end of that period, they had total outstanding debt of $11.2 billion, or an increase of $400 million, or 1% of the gross throughput. So what that means is that, on average, 99% of all card users are free riders paying off the balance in full if you measure it by the amount of charges that they put on the card. I mean, the story about 50% being interest payers might even be true, but these people are permanently stalled at their credit limits paying the minimum balance to cover the interest charges, and they never buy anything new, so they're not doing anything for the economy anyways. But if Parliament had looked at this, and even with a little bit of common sense, said, wait a minute, that story you're giving us about the free riders versus the interest payers is patently absurd.
So at this point in our discussion, now that we understand the situation, your recommendation would be, from their own personal point of view, if they're not paying them off every month, if they are carrying a balance, they should look at whether it makes sense to terminate that and send a letter. At what point do you think it becomes a significant question? At what amount of debt does this become an interesting question for a person to consider?
It's a personal thing. I mean, one of our letters we got back from, I think it's MBNA. Is there such a bank?
Yes.
Yes. Merchants Bank of North America was it used to be called. Now they issue MasterCard, and they sent in one of my letters, and he got back a letter from them saying, okay, we'll accept $3,000. I think that individual took the deal because he was under pressure from a lot of different sources. Now, I got another call from a guy in Winnipeg who said, I was talking to this fellow who said I should call you, that you're the expert on this, and I've got all these credit cards. I'm on my way down to declare bankruptcy. And he said I should talk to you first. And I said, well, okay. And I said, well, how much have you got? And he said, well, I owe $170,000 on 13 cards. But again, both of these guys are already in default. The court system and the whole system will make them look like just cheaters rather than virtuous individuals out to correct a wrong.
Nevertheless, though, is there a possibility for someone who's in that situation, already in default, of using this argument and just carrying on pushing through because ultimately they were unwittingly made party to a criminal action?
Right. That is the biggest concern and the biggest single factor, I think, in this whole process is that you can't use the card once you send the letter. Because once you know and you called them on it, you can't go around and keep spending on the card. You have to have some sort of alternative in place, some kind of debit card arrangement. There's other ways to do it. I mean, the fact that you're creditworthy enough to be acceptable to Visa and MasterCard means that you do have some resources and you're just not realizing that you have the ability to tap into them and to sort of do an end run around their system.
Well, another question then, let's say you had 5 cards and 3 of them had high balances and the other 2 were up to date. And you applied this method to those 3 cards. Could you still keep using the other ones that were up to date, or would that be some kind of vulnerability that you'd be creating in your position?
That, again, is a personal decision that you would have to make. I mean, I can't use these things because I know this material so inside, outside, and backwards that there's no way I can deny or even pretend to myself that I don't understand the full process. Now, you may go through this 20-page report and you'd say, wow, there may be something to this, and you send it into the 3 that you've already maxed out anyways, and you've still got 2 with credit limits. You could probably still continue to use those in good faith, too. I mean, you could say, look, this guy I've been listening to, he's out on Vancouver Island. He says that this whole system is criminal and that there's all these problems with it. He seems to make sense, but I don't know. I'm going to want to give you the opportunity to tell me why he's wrong. And in the meantime, I'm going to use these other 2 cards. And keep doing it until you hear from them and they convince you that what I'm telling you is wrong and that the free loan story is in fact valid.
In sum, just to complete this part of our discussion, it's always important for the person who's taking the action to be responsible for the action rather than to simply defer all the information to an expert outside source. It's a question of self-education and then using this material as your own sincerely. So to make a statement like you just made, it sounds to me like this is true. Will you please explain where it's wrong?
Exactly.
That's quite honest. And it's not just sending a letter that you don't understand, hoping that it's going to save you.
Exactly. The worst thing you could possibly do is to say, oh, there's this magic bullet out here. I can just send in this letter and I'll never hear from them again. If they sense that you don't really know what you are talking about, then they will target you as the example. You will become the one to, well, we're not going to call out somebody on this issue who really knows what they're talking about. We're going to seek out the people who are just grasping at straws, and I think they call it throwing mud at the wall and hoping something will stick.
Right. Now, in summary, at this point, with this knowledge, let's say somebody says, well, I've got 10 credit cards, and I know that there's some kind of fraud going on out there, and I can close these things down, so why don't I go max them all out and buy a car and whatever else I can afford on these cards, and then send all these letters? What would you say to that strategy?
Don't do it. It is the essence of fraud. If you're doing it from the point of view of a guilty conscience that you're going to get something for nothing by exploiting some technicality in the system, then you are morally culpable. Mea culpa, that sort of thing. It's a very dangerous thing to do because they will look for people who are doing this to make an example out of them so that they can hold it up to the whole world and say, see, this individual is simply trying to get something for nothing. And so, yeah, no, my advice would be don't do it.
So essentially it's a question of integrity and consistency. If you didn't know this was going on, you were using your credit card naively, as we all have, then when you find out, the natural thing to do is to be shocked and say, I'm not going to do this anymore, I'm not going to participate in the fraud. But once you know this, the ultimate goal is to get out of the credit system. I mean, by neutralizing the debt and going back to starting point, as it were, then you have to stop using the cards from there on in.
Yes, and to a certain extent, there is such a thing as don't kill yourself, so to speak. Don't destroy your own ability to function in the society, cutting off your nose to spite your face sort of thing. And this is what the banks rely on to a huge degree, is that technically, based on what I know, I ought to be living in a cave, because there's absolutely nothing I can do to participate in society. Every time I go out and buy a candy bar, I am advancing this system, and I ought not to do it. In fact, I should be living in a cave and not participating at all. But there is such a thing as I have to take such reasonable steps as I can figure out for myself, that without participating any more than is absolutely necessary, I'm spreading the message and saying, look, we all have to get together and somehow find a way to beat this system. But don't do it by having as your core motivation the going out and getting something for nothing, because it isn't going to work that way. What you're trying to do is stop the people who are taking away the stuff that you work for and your productive capacity and converting it to their own purposes for no good consideration. They're simply getting something for nothing, and that's what you're trying to stop.
Now, I'd like to move to a somewhat different area, although I think there's probably a relationship. What about secured debt, let's say mortgages and other loans? What, if anything, of what we've been discussing applies there, or what are the differences?
We've not had much direct success at mortgages, despite the fact that they are so flagrantly criminal in Canada. If you look at your mortgage, there's two different types. The first type is where they state right on the face of it, I, John Smith, being registered as owner of an estate in fee simple of the following lands, and in consideration of the sum of $100,000, the receipt of which is hereby acknowledged. You've got to stop for a second and ask yourself, when I signed that document at the lawyers, when it was signed, witnessed, and notarized, were those statements in fact true? And in fact, they were not true in the majority of cases. In virtually all cases, what you want the so-called loan for is to acquire the property. You're buying a new place. Then you're not the registered owner at the time that you sign the document. And in virtually every case where it's a new mortgage, the bank has not given you any money yet. And in fact, they cannot give you any money yet because they don't have it yet, because your mortgage security instrument is in fact the loan money itself. And in order to be functional as a promissory note or as a bill of exchange under the Bills of Exchange Act, the document must have the appearance of an unconditional promise to pay. And in order to be an unconditional promise to pay, it must appear as though they've already given you the loan so as they can use the security instrument as a receipt.
Let me go back just a moment, because there was an important point that you mentioned quickly. The document that you are signing is itself the funding instrument of the loan of the mortgage which you are about to take on. So you have, in fact, through your signature, created the funds which you're about to borrow. That's confusing. Can you explain that a little bit?
I was in Kelowna 2 weekends ago, and I was speaking to a fellow who did exactly this. He used his own mortgage to pay for the property. He went out, and he issued a mortgage directly to the vendor of the property, and he purchased it for the mortgage. The mortgage is money on its face. For example, it was about a $200,000 property, and he issued the mortgage directly to the vendor, and it said, I promise to pay the vendor, and secured it by the property. It obligated him at 7% to pay, I think, about $1,400 a month for the next 25 years, so as to call for a total of $420,000 for a $200,000 mortgage. What he's doing is he is hypothecating or pledging his expected future income stream of $420,000 in exchange for the privilege of creating $200,000 today for the purchase of a $200,000 market value property. The document registered at the land registry, it is the money, and when you give that to a bank instead of the vendor, the bank acts as a so-called middleman, as far as you know, but that isn't what really happens. The bank writes down in its own books that it received from you $200,000, and then it issues a new credit to the vendor for $200,000. But that credit that it issues costs it nothing to produce. It's zero, costless provision of credit. And at that moment that you hypothecate your income to that instrument, there is an actual and literal increase in purchasing power of $200,000 in the Canadian economy. So what happens is the bank tricks you into giving it to them as a gift or on the pretense that it's mere security, when in fact it is the funding instruments. They write on their own books, we received from the so-called borrower $200,000 of money or money equivalent. They don't even make a distinction between it. It's as if you gave them cash. They then issue the credit to the vendor, and at that point, that's where the $200,000 increase in purchasing power, the equity behind it, is taken from your account and put into the bank's own personal account. That's the point at which your equity is scooped.
When we say from your account, the promise to pay and the signing of the document creates this new money. So which account is it coming out of?
It's creating new present value money. Let's say that you are a steel worker or a millwright or what have you, such that you can expect over the course of your lifetime to make $1 million through 40 years of hard labor. And over that 40-year period, you are now, in this situation that I just described, you're taking $420,000 of that total lifetime capacity, and you are trading it for $200,000 today, and you're bringing it forward to the present from the future. Okay, so it's not really creating money so much as shifting it from one time frame to another. But you don't get credit for that. You have to give it to the bank as a gift, and they get the equitable credit for it.
So now in this case where the purchaser wrote the mortgage and gave it directly to the vendor without the bank in between, how is that money or value transferred to the vendor?
Well, the vendor receives an account credit from the bank, which they then reassign to somebody else. You've heard the expression, the difference between paying a debt and discharging it? Okay, it's like John owes Tom $100,000, so he says, well, Bob owes me $100,000, so why doesn't Bob just pay Tom? Nothing has been paid. All you've done is to reassign the liability, and that's all the banks ever do, but it's within the frame of reference or the context of a bubble that is ever expanding. Well, no debt is ever paid. It's only reassigned or discharged. Assume that you take $1,000 to the bank and you make a deposit. Okay, the moment you make that deposit, the property interest in the currency, the, say, Federal Reserve notes or the Canadian currency from the Bank of Canada, it passes to the bank. It's now the bank's property. Now, run the same scenario through your mind with $1 million and $1 billion. And someone in the country inherits $1 billion from somebody outside the country, and they take it down to the bank and make a deposit. Okay, the moment they do so, the bank is $1 billion richer than it was the instant before. Then the bank issues $1 billion credit back to the person who made the deposit. At that point, there is $1 billion increase in the total amount of purchasing power in society. Because what we're constantly confusing is a deposit for what is technically a reposit. You've heard the term repository?
Mm-hmm.
Okay. As opposed to a depository. With a repository, the property interest in the money stays with the person who makes the reposit. It's like a safety deposit box, which is actually, of course, a safety reposit box. It still remains to be your money. And the cost to you is outstanding. You could virtually eliminate the federal income tax, and all the government has to do is insist that the banks actually have the money that they owe people. The point is that when you go down and you make a deposit and the bank issues a new instrument called an account credit in the same amount, then at that point there is an increase in the money supply, and that's where all this inflation is coming from. Before the deposit, let's say that we're dealing with $1 million.
Mm-hmm.
You find $1 million in gold or something, or cash even, and you take it down to the bank. Before the deposit, there's $1 million that you own and can spend. Fairly straightforward. After the deposit, relatively speaking, there's $1 million that the bank now owns and can spend if it wants to, and there is $1 million account credit that you own and you can spend if you want to. There has, on its face, been an increase of $1 million in purchasing power supply, and that happens every time a deposit is made. And that is the point at which our system is revealed to be a constructive fraud against equity. The fact that property interest in the real money passes from the depositor to the bank in exchange for a consideration that costs the bank nothing to produce. You fix that problem, you fix the whole world.
This raises two questions. You're paying off a mortgage and times are tight and you can't make your payments, and then you're in a situation where if you start missing payments, you could be subject to foreclosure. Is there, based on the information we've been talking about, a strategy, a remedy to undo some kind of hidden fraud which has been in existence that you didn't know about up until this time?
It's essentially the same as it was for the unsecured debt, only you have to go about it in a little bit different way. you must confront them with it and demand that they explain their actions. And it depends on the nature of your paper, so to speak. As I said, there are two ways they can do this. The one is the categorically false statement on the face of the mortgage that you've already received the money. That's an offense under Section 388 of the Criminal Code. It's a constructive forgery. The other possibility, and which is becoming increasingly prevalent, is that they will state on the face of the mortgage that in exchange for their bare agreement to loan you $100,000, you agree to give them the $100,000 in the form of the mortgage security. And then they loan it back to you, your own money, but they call it a loan, and you have to pay it back again plus interest. Now, in that case, you've got what is called a fictitious consideration on the face of the mortgage. The bank has to make a declaration under its annual reports that it recognizes that its bare agreement to loan is not a good and valuable consideration in and of itself. The only thing a borrower ever wants is the money, and that's the only thing of value that a bank ever provides in theory. So you've got a contract that states on its face, and they always follow it up with, neither the execution or registration of this mortgage shall bind the bank to advance the principal amount, but you agree that you owe us the $200,000 or the $100,000 anyway. And so you've got a fictitious consideration, a contract that states on its face, you agree that we've done nothing for you, and in return, you agree that you owe us all this money. It's a phony contract on its face. There's a process that you can go through. It's very difficult and dicey when you're dealing with a chartered bank due to the existence of Section 434, subsection 2 of the Bank Act, that is retroactive legislation, and it says, to paraphrase, nothing in any act, charter, or law shall be construed as preventing a bank from acting on any power of sale contained in any mortgage document held by the bank. So it says no power in the universe can stop a bank from foreclosing on a mortgage. But the flaw in that is that if it is a constructive forgery, then it isn't a mortgage in law, and so they wouldn't be able to act on that. What you're dealing with there is you've got evidence right staring you in the face. There's no competent government acting in good faith would ever enact such a law that says nothing in any act, charter, or law, including the Constitution itself, can stop a bank from realizing on a mortgage. On its face, that law is invalid. But what it does demonstrate is if you're going to do this, you have to do it in groups. Don't try and do it on your own. Get together with 10 other people in the same boat and attack the problem as a group collectively. 30 people would be better, 50 is even better still. But if you go in by yourself, they're going to see that you're vulnerable, and they're going to pick you off one way or another. And when these things go to court, especially with land mortgages, what happens is that I have never, ever seen the bank win. Every single case always ends with the court picking off your defenses one at a time. You can't raise this defense, you can't raise this defense, and you can't raise this defense. Therefore, the bank wins by default. The bank always wins by default. And it's a complex question, but there are remedies out there.
I misunderstood something you just said, where you said you've never seen the bank win?
No, I've never seen the bank win outright.
Win outright,
right.
But by default,
it's always
by eliminating your defenses.
Right. If you think of it as a hockey game or a soccer match, the other team, the borrower, is always disqualified.
I see.
But because the bank is incapable of scoring any goals. It can only have you disqualified, and it wins by default. And that's taken me 10 years to learn, but it's becoming increasingly manifest, and there are ways to exploit it.
In the long run, it looks like there might be as effective a remedy in the case of the mortgage, but it's still in process of being perfected.
Yes, one potential way to go about this, and this has just occurred to me in the last couple of weeks, is that a third party could be given a mortgage. And then if that third party, say you've got a technical forged mortgage, constructive forgery in law, for $100,000 on your property, well, you give your neighbor John a $100,000 second mortgage, and then John can go to the courts and make application as a third party with an interest in your property to have the bank's mortgage stricken as a fraudulent instrument. It would have to be done in a certain way. But the thing is that, you see, the third party, essentially you're doing the same thing under the Bills of Exchange Act. The Bills of Exchange Act only deals with commercial paper, who is a holder in due course, and who is entitled to it without notice of defect and all of this other stuff. They don't care about the equities involved. The point is that I have a right to this property. My mortgage is good because it tells the truth. Your mortgage, Mr. Banker, is a constructive forgery because it contains an objectively false statement and a material false statement on its face that you had already given the money when you hadn't. And therefore, I am entitled in equity to have your mortgage stricken and mine put in its stead. That is the process that I'm working on right now. It's a little premature just yet, but in theory, that is the remedy that you're entitled to.
To conclude this, what I've learned is that in both secured and unsecured debt, Essentially what you're doing is you're holding the banks responsible for the language which they have created on the instruments which they've asked you to sign. So you're not tricking them, you're untricking yourself.
Yes, exactly. Essentially, now look at it this way. When you make that false statement on the mortgage that you've already received the money from the bank, who is making that false statement? Is it the banker or is it you? See, it's you that's making the false statement because it's your paper. You are issuing that security as a false receipt for money already had and received. So what the bank is doing technically is requiring that you falsify the documents so that technically your hands are dirty and you can't raise that as an issue when you go to court. So what you have to do is you have to throw everything down on the table and argue equity from the outset. You don't ever want to argue law with these people because the courts have to give you equity if you argue equity. And so there's a way to do that. It sounds real simple here, but you have to know what you're doing and you have to be able to go in and say, I don't care what the mortgage says. This is equity. I want an equitable accounting of this transaction. Who brought the money to the transaction? And in fact, it's the borrower. The bank arrived at the transaction with nothing and walked away with $200,000. So if there is an audit of the equities, the bank will always lose. And if the bank loses the audit of the equities, the courts can't help them because they put nothing into it. They're not entitled to take anything away.
We're continuing now to talk with Tim Madden about the economics